Did you know India has a hidden treasure? It's called fundamental rights, guaranteed by our Constitution under Part 3, Articles 12 to 35. These rights guarantee your liberty, equality, and protection, and they are justiciable, so you can directly approach the courts. But they're not absolute. The state can impose reasonable restrictions for public order, morality, or national security. Certain rights are for citizens only, like Articles 15, 16, 19, 29, and 30. Others belong to everyone, even foreigners. Parliament can amend these rights, but the basic structure must remain intact as ruled in the Keshavananda Bharati case, 1973. During an emergency, rights can be suspended, but life and liberty are untouchable. The Supreme Court protects these rights. Article 32 is your sword against injustice. High courts also hold power under Article 226. Fundamental rights are the foundation of democracy, ensuring every citizen lives with dignity. This isn't just law, it's a promise that defines our very existence. We should first know who must protect your rights. It all starts with Article 12. The state includes many players. Even private companies can be involved. Why does it matter? Here's why. Fundamental rights can be claimed only against the state, except for Articles 17, 23, and 24. Now, Article 13 comes into play. It invalidates any law violating rights. This empowers courts with judicial review. Famous cases illustrate this power. Shankari Prasad case, 1951. It ruled that amendments are not laws under Article 13. Keshavananda Bharati case, 1973. A turning point. Minerva Mills case, 1980, it balanced fundamental rights and directive principles. So remember, Article 12 tells who must follow your rights, and Article 13 tells how courts protect them. Your rights are not just words. They are backed by laws and justice. Stand firm, for your rights are worth fighting for. What if I told you everyone deserves equality? It starts with Article 14. No one is above the law. This principle, rooted in British law, ensures equal protection under the law. Next, Article 15 says, no discrimination. It protects against bias based on race, religion, gender, or where you were born. But wait, the state can offer special provisions, especially for women, children, and the underprivileged. Then comes Article 16, equal opportunity in jobs. Reservations for backward classes and EWS are allowed. And in the famous Indra Soni case in 1992, the Supreme Court upheld the 27% OBC quota, created creamy layer, and said no reservation in promotions. Article 17 abolishes untouchability completely. To enforce this, we have Protection of Civil Rights Act, 1976. Finally, Article 18 states, no titles or special status, except for military or academic titles. Even prestigious awards like Padma are allowed. This was confirmed in the Balaji Raghavan case. So remember, Articles 14 to 18 together form a story of fairness, dignity, and equal opportunity for every Indian. What if freedom was a story? In India, every person should live freely. Article 19 gives 6 basic freedoms to citizens: to speak, assemble peacefully, form groups, move anywhere, live anywhere, and choose any profession. Earlier, the right to property was also here, but it was removed and shifted to Article 300A. Then comes Article 20, which protects you if you are accused of a crime. Under this, you cannot be punished under a law that was not in force when the act was done. This protects you from ex post facto laws. You cannot be tried or punished twice for the same offense. This ensures freedom from double jeopardy. You cannot be forced to give a confession against yourself. This guards you from self-incrimination. Now, Article 21 is the heart, the right to life and personal liberty. In the Maneka Gandhi case, the court said, life means living with dignity. So this includes the right to privacy, health, clean environment, safe roads, shelter, and even internet access. Finally, Article 21A ensures education. Every child aged 6 to 14 gets free education. The right to freedom protects your voice, your movement, dignity, safety, and education. Remember, the right to freedom doesn't end here. Article 22 is also part of this same right. What happens when you're arrested? The Constitution protects you through Article 22. First, Article 22 says the police must tell you the reason for your arrest, clearly and immediately. No secrets, no guessing. Second, you have the right to a lawyer, so you are never alone in the process. Third, you must be brought before a magistrate within 24 hours. This ensures nobody is kept in custody unnecessarily. This is called ordinary arrest protection, and it applies to everyone. But Article 22 also talks about preventive detention. This is when someone is detained not for a crime already done, but to prevent a possible threat to national security or public order. But even here, there are limits. A person can be detained for a maximum of 3 months, unless a special advisory board reviews the case and approves a longer period. So, what's the message here? Even during arrest, the Constitution stands with you. That's the power of Article 22. Your rights matter, never forget. The Constitution is your shield. Stand up for your rights. Article 22 is here to protect you. What if exploitation could be abolished? Article 23 protects the most vulnerable. It bans human trafficking entirely. No one is forced to work against their will. Slavery and bonded labor are illegal. To strengthen this, Parliament also made laws like the Immoral Traffic Prevention Act. But what happens if wages fall below minimum? It is also classified as forced labor. There's one exception though. The state can require compulsory public service, yet it cannot discriminate while doing so. Article 24 protects children from harm. No child under 14 in hazardous jobs. However, simple, harmless work is allowed only if it does not disturb the child's education. In the famous Sivakasi firecrackers case, the Supreme Court banned children from firecracker units. A rehabilitation fund was also established. Together, Articles 23 and 24 ensure safety. They protect dignity and humanity. India is a secular country, which means the state doesn't promote or oppose any religion, but treats all religions equally. Article 25 gives every individual the freedom to believe, practice, and even spread their religion. But this freedom is not absolute. The state can restrict it for public order, morality, and health. And only essential religious practices are protected. This is what the Supreme Court said in the Shirer Mutt case. Article 26 protects religious groups. Any religious denomination can manage its own religious affairs and institutions, as long as it doesn't disturb public order. Article 27 ensures fairness. No one can be forced to pay taxes for promoting any particular religion, but the state can support all religions equally. Now, Article 28 deals with education. Religious instruction is banned in government schools. In private schools, student and parent consent is required. And in the Aruna Roy case, the Supreme Court clarified that value-based education is allowed, only religious instruction is banned. Together, these articles ensure harmony, freedom, equality, and respect. This is the essence of secular India. India has hundreds of languages and cultures, and the Constitution makes sure none of them disappear. Article 29 protects any group of citizens with a distinct language, script, or culture. No student can be denied admission in a state-run or state-aided educational institution just because of religion, race, caste, or language. Article 30 focuses on minority rights, both religious and linguistic. Religious minorities are identified nationally by the central government under the Minorities Act. Linguistic minorities are identified statewise, because each state has a different main language. These minorities have the right to establish and run their own educational institutions. The Supreme Court in the TMA Pai case, 2002, clarified that minorities should be identified statewise, and their institutions have the freedom to decide their teachers, staff, fee structure, and admission rules. But these rights aren't unlimited. The state can regulate education standards. Also, minority institutions do not have a fundamental right to get government recognition or funds. And reservation laws don't apply to minority institutions. In simple terms, Article 29 protects culture, Article 30 protects institutions, and together they protect India's linguistic and religious diversity. All our fundamental rights become real because of one powerful article, Article 32. Dr. B.R. Ambedkar called it the heart and soul of the Constitution. Article 32 gives every person a direct guarantee. If any fundamental right is violated, you can go straight to the Supreme Court for help. You don't have to wait or approach lower courts first. To protect your rights, the Supreme Court can issue writs, which means special orders that stop illegal detention, force authorities to do their duty, prevent misuse of power, or remove someone illegally holding a public office. The strength of Article 32 is that itself is a fundamental right, which means the Supreme Court must ordinarily accept such petitions. During a national emergency, this right can be restricted, but Articles 20 and 21 can never be suspended. In essence, Article 32 is your shield, a shield against any violation of rights. In the next video, we discuss those writs. We understood that Article 32 lets us go straight to the Supreme Court when our fundamental rights are violated. But how does the court actually protect us? It uses something called writs, which means special orders that stop any misuse of power. First, habeas corpus is the writ of freedom. If someone is illegally detained, the court immediately says, "Bring the person here right now." It is the strongest protection of personal liberty. Next, mandamus is like the court giving a command. If a public authority refuses to do its duty, the court says, "Do your job." This writ cannot be issued against private bodies. Then comes prohibition, the court telling a lower court, "Stop. You are going beyond your powers." Next, we see certiorari. Here, the higher court actually cancels the illegal order of a lower court or tribunal when it makes an error of law. And then there's quo warranto. It asks, by what authority are you holding this public office? If someone occupies a post illegally, the court can remove them. These writs are powerful tools. They keep authorities in check. Remember, there's more. Article 226. High courts issue writs too, and their power is even wider. They protect not just rights, but legal rights too. That's how our Constitution guards us. Fundamental rights can be restricted, but only under specific conditions. Article 33 allows Parliament to limit rights, especially for those in uniform. This includes the armed forces and police. These roles need discipline and secrecy, so rights like free speech or association can be limited under laws such as the Army Act. And only Parliament can do this, not the states. Article 34 addresses martial law. When civil administration breaks down and the military steps in to restore order. During this period, Parliament can give legal protection to actions taken by officials, even if some rights are affected. But the Supreme Court has made it clear, habeas corpus is not automatically suspended. Article 35 gives exclusive power to Parliament to make laws on crucial issues. This includes punishing untouchability and addressing child labor and forced labor, etc. Article 35 ensures uniform laws across India. In summary, Article 33 limits for security, 34 applies during martial law, and 35 creates uniformity. With this, the fundamental rights chapter is complete.